Good afternoon everyone, and welcome to today's webinar covering an introductory insight into legal issues facing road authorities. My name is Neela McCoy and I'll be your moderator today. Please feel free to contact me if you've got any webinar related inquiries, and my contact details are just on the screen. Today's webinar will run for approximately 30 to 40 minutes and will allow 20 minutes for some questions. At the conclusion of the presentation, it will be made available via email. Now, webinars work best when there's lots of interaction, so please feel free to type in any questions that you may have into the questions box. Now, without any further delay, let's welcome Paul Hillier from ARB Group. Paul, I know you're going to launch into a poll question, but before we do, could you kindly tell us a little bit about yourself?
Sure, thanks very much. Welcome everybody this afternoon, wherever you are from around Australia, and indeed hopefully some international guests. My name is Paul Hillier. I work from the ARB Sydney office, but I get around the country in a national role and indeed working internationally. So I work in lots of things to do with risk, network management, road safety, traffic engineering. So quite a wide gamut of work, but mainly where there's some sort of risk involved, and trying to develop things which will help with good, positive road safety outcomes.
Now, to launch into our first poll question today, Paul's wanting to know, within the road agencies, should you always be liable for crashes when the road environment is found to be defective? Do we agree or disagree? And I'll just launch that right now. So if you could please provide your answers. Paul, do you have any idea of what the answer might be?
Well, it's an interesting one, and I guess as usual I've been a little bit crafty with the question. The word always and liability in terms of total liability, some interesting concepts there that we'll just want to see what people have put, just to see how they're thinking and whether they have any insight already into this particular issue. So I'm expecting, I think, a bit of a mix of answers.
Okay, great. Let's have a look at what we've got. I'll just close this off and share those answers. Okay, so we've got 43% agree and 57% disagree. What does that tell us?
Well, it's good. It's kind of what I expected. I think people are thinking about in the right way, that if the road agency generally acts negligently and does something really, really badly and makes an error, then people should be liable for compensation if the road was defective. However, we need to think a little bit more widely before making our decision on this. The word always, should it always be liable? Well, rarely a road authority is held 100% liable in any particular case or claim against them. There are lots of other multiple factors, lots of other parties involved, and indeed the actions or omissions of the people involved in the crash in terms of the drivers, maybe a string of contractors, consultants, etc., etc. But also think about our vast road networks, think about our road network hierarchies and how many roads we have to manage and maintain, and also the fact, do we actually have knowledge of the particular defect to do something about it? Could have come on very quickly, localised spell of bad weather. So it's not quite a clear-cut question, and so quite pleased that we've got a bit of a split there in answers.
Mm-hmm.
What I'd like to do now, as the name of the webinar implied, is just to do a very quick recap on highways liability or road agency liability. It is within the confines of the webinar, quite a short introduction, but hopefully it will set the scene and people will whet their appetite a bit for knowing more, and there'll be some more information a little bit later on that. Liability claims, yes, they remain an important consideration for us. They can cost us an awful lot of money as road agencies, depending on how our insurance is set up and our civil liability insurance. But also, let's not forget that if we have incidents on the highway, it can have a major adverse effect on the coverage we get in the media and our reputation. So not just thinking in terms of dollar value, but also other things which can impinge upon our reputation and how we're seen by the members of the public that we're serving. And that next one is a good segue, I guess, to why we're vulnerable in these sort of situations. Well, basically, the road network is invaluable to society, and unfortunately, as good a job as we try and do, people still have incidents and crashes. I prefer not to use the word accidents, as you can see they're crossed out. I prefer to use the term incidents and crashes. And when those occur, as sad as they are, they deserve investigation. And what tends to happen is the road gets put under a lot of scrutiny. Everybody's an expert about what we should and shouldn't do. And I say that with a little bit of tongue-in-cheek. We're all aware of the backyard barbecue where everybody's telling us how we should be running our roads. But we must take a step back and remember that we're there to serve the public. We're a public body, and we have a duty of care to the people using the roads. There are a few other things, though. There is what we call a litigious culture at the moment around that somebody must pay type culture. If somebody gets injured, then there's an expectation that they will get compensation. And indeed, going back a little while now, the road agencies were seen as a very easy target for third-party claims. Not so much now, as I'll touch upon in a little while, but nonetheless it still exists. We're seen to have deep pockets. But that's a few subtle reasons, but the real specific reason why we're vulnerable to claims is that in very basic terms, there's nothing in legislation to stop people bringing those claims. The situation is subtly different in each state. I must say that, in each state and territory, so you need to be aware of the situation in your particular area. But in general terms, there's no legislation preventing people from bringing these claims. And I guess from our initial answer, our initial poll question, people would see that as being a good thing, I would suggest, in a few cases. But on the other hand, it's not all the sky falling in. It's not all doom and gloom. There are a few important points from the aspect of the road agency. There are rules of the game, and that's important. And one of these is that the onus of proof is always with the claimant, or what we call the plaintiff in legal terms. So the person bringing the claim, alleging the defective infrastructure, has to set out their case. What we call the burden of proof is very different in these cases. In civil cases involving compensation, it's on a balance of probability basis. Now, you're probably more familiar, I guess, with the criminal cases and beyond reasonable doubt. It is a slightly different game, slightly different rule. The road agency, as I mentioned, is likely to be one of many defendants, and in legal terms, that means you can get cross and counter claims, and things can get quite complex and quite messy. And importantly, as I touched upon earlier, the road agency is rarely 100% liable. And I've put it in figure terms there because it is discussed in just those ways. As you can imagine, the insurance companies will haggle over the percentage liability for their particular client, and you will see it set out in percentage terms. The road authority might be held 65% liable or 30% liable, and other percentages are offset against other parties that are involved. So it is seen in those sort of terms. When a claim comes and it ultimately goes the distance, we have an opportunity or a decision to make whether we're going to defend it in some way. And our test and our defence, I guess, is whether we're able to demonstrate that we've effected reasonable measures in managing and maintaining the highway. Now that's a very important point, reasonable measures. Yeah, there are very few definitions of what reasonableness, there are a few pointers to guide us, but it can mean a few things to different people. So reasonable measures in managing and maintaining. We have to demonstrate that we've done that. But importantly, a number of key judgments around about 2002 where we had a civil liability crisis, not just in terms of roads, but also in other terms of civil liability. It was held in a roads case that the world is not a bowling green. Now, what does that mean? Well, basically the judges in a particular case said there was no expectation that the road environment should be in a perfect state of repair at all times. They understand that the networks are vast. They understand that different roads carry different amounts of traffic, that different roads have different importance on the network. One of the other things that came out around 2002 was that also people should be able to take more personal responsibility for themselves. There is an expectation now, whereas previously the courts were a little bit more lenient on people that had perhaps slipped, tripped and fallen as pedestrians. Now, if the hole or pothole, etc., might be in the footpath is so obvious, they expect people to walk around it now and not bring claims against the road authority. I've put the pendulum there because basically road agency liability does tend to work in those terms. It swings backwards and forwards. Just to stress at the moment, my personal opinion, and that of a number of commentators also, is that we're in a position at the moment where things are favouring the road authorities to some degree, or they're certainly a lot more helpful to us than they were, say, 12, 15 years ago. So, what are a few tips for us as road agencies? How can we stop these claims? Well, we can do one or two things, I guess. We can decide to fight everything. We can just put up the ramparts or the barrel gate and we can say, look, we're just going to defend everything. We know what we're doing as a road agency. We can't possibly have done anything wrong. Well, does that really help anybody? And certainly my philosophy is certainly the best way to stop incidents and claims happening is to prevent incidents from happening in the first place. If you don't have any incidents, you don't have any claims. And from our road agency perspective, things like our strategies and our policies and our standards, our procedures, they're our safety net. And having those and being able to demonstrate that we're consistently implementing them will go a long way to satisfying our test, that we're showing that we're demonstrating reasonable measures in managing and maintaining the highway. The test is also whether we have things in place that are what we call just the basic building blocks, if you like. We have inventories, we have hierarchies, we have condition data. Basically those solid foundations in place. If we don't, how are we supposed to manage and maintain the highway? So it's important that we give due reference to these things. Obviously, if we are looking to demonstrate, well, record keeping becomes important. Now, record keeping is about collecting records and keeping them of the right things. It is not about record keeping to collect everything. And that's a very subtle point, and one that we can certainly help you with, and we can certainly talk about during our other workshops and courses we do on liability. Okay, hopefully that's given people a bit of an insight. I better just stop just for a few seconds and check that everybody's travelling before we go into perhaps the main part of the webinar today. How are people going?
Thanks for that, Paul. I haven't had any questions come through yet, so just a reminder to people, please don't be shy. If you want to ask Paul anything, please just jump into the questions box and type away, and we'll get them addressed. Paul, I do have a question for you. Is there any way, or how can we demonstrate that reasonable measures been done?
Well, it's quite a task, as you can imagine, that we need to be disciplined about it, and we need to work out how we are going about meeting our objectives that we might set for ourselves as the road agency, how our policies and our strategies feed into those to deliver those, making sure that what we say that we're going to do, that we actually do it. Now, in terms of gauging whether what we're doing ourselves is reasonable, whether things like codes of practice and guidance that we can be tested against, and also, importantly, don't forget we have neighbouring road agencies. We have our peers, if you like, that can be judged against. We often say in liability that our neighbours can be our best friends or our worst enemies, depending on what sort of policies they set, and we encourage people to talk and to communicate about what standards and policies they're setting. So it's a bit of a long answer, but I guess what we're saying is that we need to set out our case, we need to set out what we've been doing and how we've reached the decisions in terms of setting our policy.
Okay, fantastic.
Just a question of mine perhaps, do we have anybody in the audience from Victoria? I wonder if people can indicate through the discussion box whether we have anybody from Victoria.
Yeah, if you just want to put your hand up if you are from Victoria, and we'll just let Well, no,
Don't be shy. You're not in trouble.
yeah, we've got Hugh Dixon here from Victoria. Is there anyone else? Oh, looks like you might be the only one. Yeah, that's the only response.
Oh, well, Hugh... Okay, well, Hugh may be outnumbered, but he's going to be very, very important to us in this next bit. So keep listening, Hugh, and we'll explain why.
Okay.
I've got a bit of a poll question here. These claims that are made against road agencies for defective infrastructure, are they brought for A, breach of statutory duty, B, breach of the duty of care, C, under nuisance, or all of the above? What do the legal people working for the people who've had accidents or injuries, what do they tend to bring them under? A, B, C, or D? What do you think?
Great, so we'll just wait for those answers to come in if people just want to put in their votes. Paul, can you predict what the outcome might be of this poll?
Oh, I think there might be a fair few Bs, because I think we've mentioned duty of care before, but I'm hoping there may be lots of Ds.
Okay. All right, I'll be closing it shortly, so if you could please get your votes in. All right, let's have a look at the responses here. Just close that off and share those results. Okay, so we've got 13% breach of statutory duty, 63% Paul, as you predicted, breach of duty of care, 0% nuisance, and, oh no, Paul, you predicted 25% all of the above. But we've got...
Okay, well, the strict answer is all of the above. Now, the percentages or how they're split up may well vary or will vary depending on what state or territory you're in. If you are in Victoria or if you're in the UK, a breach of statutory duty would be pretty much your main ones. If you are in any other parts of Australia, breach of the duty of care, or they're heard under the principles, general principles of negligence, is the main course. So B, if you're in other parts of the country. C, you can get the odd claim brought under nuisance. That tends to be for very specific things, like doggy do on the footpath, or complaints about noise during construction activities, etc., etc. So the answer is a bit of all of the above, but let's go through and have a little look at these. We're going to look at A and B in some detail, and here we go for Hugh. We're going to have a look at Victoria, but it's really important that other people don't switch off now, because it shows how this duty of breach of statutory duty is framed and how it works. The civil liability crisis that I mentioned around about 2001, 2002 led to a lot of state and territory legislation. And in Victoria, it introduced a bit of a holding pattern until what was called the Road Management Act 2004 was developed and brought in. And there it is, as you can see it there. What this has done is it's adopted a kind of, or very close to, the UK model, where it actually sets out the powers and duties of the road authority in quite some detail. And you'll see I'll pick out a few items here, particularly item number 40, the statutory duty to inspect, maintain, repair public roads. So there's that statutory duty where people can say, I've had an injury, or as a result of your road being defective, you have a statutory duty to inspect, maintain and repair. Please provide your response as to why you didn't affect that duty, or indeed if you believe that you fulfilled that duty. What the Act also does, though, which I think is very good, is that it actually sets out to the road authorities how they can go about ensuring that they are fulfilling their duty. And it sets that out also within the Act. So it's very, very useful in that particular regard. 48, specific duties and powers in relation to infrastructure and works on the road. Just a few highlights there I'm picking out. And then if we go over the page, as you can see, there's lots of different acts there. But there's also a section on civil liability to set out what the limitations of liability on the road authority are, what the policy defence can be. So it's quite actually a powerful tool that the road road agencies can become familiar with, be aware of and respond to, and that was the general idea of it all. The other one that I wanted to talk about is the breach of duty of care, and as I mentioned, these particular claims tend to be heard under what we call the general principles of negligence. So here's our breach of duty of care type claims. But what I want to do is explain in terms of a few specific situations to make people aware in practical terms of what this might look like or what it might mean. I want to take a step back first though. A few years ago now, before certain legislation came in the claims alleging a breach of duty of care, people tended to have a bit of a fishing expedition. They tended to have a bit of a dollar each way, I call it, where they might say, oh look, we believe the road surface was defective, it was slippery, oh and what about the line markings, oh and what about the signs, what about the street lighting? So they tended to have a bit of a fish, if you like, on each particular part of the road infrastructure. Now that's been disallowed now by legislation in most states, and the claims have to be quite highly specific, as we'll go on to here. In terms of some road surfacing type claims, I thought it would be actually worthwhile bringing them up. But how do people frame these claims in general terms? Well, let's have a look at some of the words that people use. I thought it was useful that we brought it alive by people can see what sort of things the legal profession allege. So here's a few. I'm going to read a few out. You've led my client into a trap. Or importantly, they might say, you forced my client into a mistake that every reasonable road user would have made because you put the road infrastructure in such a position or such a way that you forced my client into a mistake. Everybody would have made that mistake. More generally, as it comes down, here's our duty of care type references, and these are just indicative type statements. The road agency owed a duty of care to my client and breached that duty of care. The road agency was negligent. And obviously we need to respond to these. We have to do that. And as you can see, that's quite a broad question for us to respond to. We can mention a number of things. We can mention how our objectives and our things link into our policy, etc., etc. But it all takes time, and we've got to have documentation to back it all up. A few more specific ones: failed to rectify defects in the road surface, failed to carry out investigation or remedial work, failed to put in place appropriate signage. That's quite an interesting one. Often putting out some warning signage will be sufficient to assist us to show that what we've done is reasonable if we can't effect an immediate repair, or indeed we have more pressing demands or more competing demands for our money and our time and our resources. So as I mentioned, a few road surfacing related ones. I'm conscious we've got a few people in here who deal with asset type management. And also I think we've got Rob Bassetil from APA, so if you're listening, Rob, today. A few cases, for example, with respect to skidding resistance, or as we might term grip or friction. And as you can see there, quite a badly flush, bleeding picture of a road surface there. What sort of things do they allege in terms of this sort of case? Well, failure to maintain the road, failure to provide adequate friction. The vehicle was caused to lose control by a lack of friction or traction is often a word that they'll use. And indeed, three is quite an interesting one. Failing to adequately reduce the speed limit where there was sort of defective road surface. So they're quite cute, or quite astute, you could say, in the way that they frame their questions. So they understand that often putting up warning signs, putting up speed limit reductions can be quite effective a particular site. So they understand the game. Failing to adequately warn, failing to post a lower advisory speed limit is another example of how they set that out. Failing to resurface the road in accordance with nationally accepted codes of best practice, and this tends to be with respect to our spray seal type cases, our chip sealing in New Zealand. Rolling and sweeping operations often come under quite a lot of scrutiny, and I'll come back to those in a tick. So flushing and bleeding, yes, we often have to debate on through photographs or through our condition data whether the road was flushed or bleeding, and what extent, over what area, what we did about it, what actions and decisions that we made, and that leads us in often, or nearly always, to our programs of work. This particular road section, whereabouts was it in our overall scheme of things on a particular route or indeed a particular area? How do we prioritise which sections we were going to do remedial work on? We can also have polished pavements, as you can see on the left here and bottom right, quite bad examples of polished pavement, and then something a little bit more reasonable there on the top right. So again, how long has the road been like that? How can we prove whether we had actual knowledge or indeed didn't have actual knowledge of the road being in that condition? Now often there will be requests for the road condition data, and we need to manage that well. We need to be able to find it, we need to be able to prove that we've used it and we've collected it, and that can often be a bit of a problem. Aquaplaning, skidding type crashes, obviously we get these, and this is where a number of claims are generated often for people having crashes, leaving the road, combining with embankments or trees, can be some quite bad outcomes. On aquaplaning type cases, just some indicative type sites here. The bottom right is very indicative of cases where we get loss of control on the wet and aquaplaning, where we get water coming across the road if we haven't got the drainage quite right or we've got transitioning crossbores. It doesn't tend to be the scenes on the right there where there's lots of surface water and it's more obvious in terms of the hazard. So in terms of aquaplaning type cases, the things that people are looking for, or the things that we might want to collect and use in our defence, things like where was the water, how deep was it, how long did it last, the road geometry, the drainage and maintenance of the drainage, but also a whole heap of things to do with the vehicle itself on aquaplaning type cases. So the vehicle characteristics, the tyre characteristics, and what the driver did in terms of manoeuvring the vehicle. So there's a lot of considerations. We tend to get a lot of claims on loose aggregate contamination. As you can see there, various different scenarios where this might have occurred. On the top left, there was a lot of speculation about, a lot of discussion about whether the works could have been scheduled in a slightly different way so that nobody was left exposed to the loose aggregate that was left overnight on this particular site. On the right-hand side of the slide, this is where we have encroachment onto the road surface by debris. In this case, often unsealed road that abuts the main road there, and the discussion about what the road agency could reasonably have done in this particular case. But also more localised, as you can see bottom left there, a localised spill of aggregate or detritus, whatever that is there, on the approach to a set of traffic signals and a stop or give-way line on this particular location. How could it have been there? Could the road agency have prevented that in any way through its management of the highway? Could have been caused by an adjoining land use. How did the road agency liaise and communicate with these people if this happened regularly to stop it occurring? What could they have done? I mentioned spray ceiling type cases, get a lot of claims outside of Victoria, I hasten to add, but a lot of claims on spray ceiling. Basically the rates of spread of the binder and of the chippings, how they've been rolled in. Can you prove the number of passes on the roller? When was it rolled? Was it rolled correctly with the right machines, etc.? And then the sweeping operations. Was there any loose aggregate left there which could impinge upon the people using the road after its initial laying? Had the sweeping been done on the required frequency, etc., etc. But increasingly as well, or importantly, to do with signage on spray seal type cases. Were the signs there reducing the speed? Were there warning signs? Had the road been rightly opened up to unrestricted traffic again? Were there things like top right, stick and stomp markers placed back to indicate the middle of the carriageway? So a lot of things to consider in these sort of cases, and I'm hoping that you'll get some sort of a feel as we're going through as to the pressures that we have in terms of providing documentation. This could be 2, 3, 4 years down the track since the incident occurred and it's first come into us. We need to be having good systems, good record keeping to be able to defend them if we feel we have a good case. We've effected those reasonable measures in managing and maintaining the highway. Another group of people, we often get some claims about our two-wheeled friends, and that could be motorcyclists, it could be pedal cyclists, particularly vulnerable for things like lease agri on the roads and contamination, but also in situations like this, where we have localised repairs. Here you can see on the left here we have some, what I call my UK background, overbanding, but you can say crack sealing, where there's been some cracking in the road and a bituminous sealant has been used. That tends to not have particularly high skid resistance. Some people put grip and things on that. But the extent of that, as you can imagine, can be quite a risk or hazard in certain situations for motorcyclists. Just as can large bulk line markings or has arrows, as you can see on the right-hand side, or indeed where we have things like old line markings blacked out, using things just like black paint, can be particularly risk or introduce particular risk to our two-wheeled friends using the road. So we get a lot of this sort of scenarios coming to us when we're looking at claims for road agencies. Okay. Sorry, I'm having trouble with my mouse today on the mouse mat. It's not moving around very freely. I just wanted to check before we finish things off and open it out more widely to questions. Just wanted to check that people were okay with the last segment where we were talking about the claim mechanisms and some of the things on to do with surfacing. How are people going now?
Yeah, I haven't had any questions come in, so just another reminder to jump in if you want to ask Paul anything. Paul, I was just wondering, we did touch on motorbikes, and is this the same concept for a pedal cyclist?
Absolutely, absolutely right. If you think about a car, you have, well, even a car can be quite daunting if you think about the 4 palm-sized contact patches between your tyre and the road. That's all that's keeping you on the road. And if you can imagine a motorcycle, well, yes, and 2 of those hand-sized type patches, perhaps smaller, but then go on to think about a pedal cycle, smaller again. You can soon see why they're particularly vulnerable, where there's changes in the level of friction provided by the road or the level of grip provided by the road. Can be particularly vulnerable and risky, and we need to obviously be aware, particularly where we have high volumes, high percentage volumes of people using those types of machines. We need to be spot on with regard to our policies and our practices on those roads.
Okay, great, fantastic. So still no questions, so guys just jump in when you want to ask Paul something.
Okay, I'm getting away very easily, but don't forget the idea of these webinars is to provide access to the presenter as well. So at the end there'll be my email. If you feel like answering some questions or you're not sure what I said or did you hear that correctly, then please just drop me a line. I'm more than happy to respond to them. So that's been a bit of an insight into third-party liability, claims against road agencies, I often hear it called, highways liability, you might hear it in some terms. And hopefully, for those of you that's been new information, that might have whet your appetite a bit for a bit more knowledge. It might have given you a bit of context, which is great. If you are aware of some of the concepts, you've heard about this a little bit this morning, hopefully the road surfacing examples that I brought in and the way in which the legal people bring claims against road agencies was new information for you today, and this additional will help you understand why they write in that way, why they make the allegations that they do. One of the things I've got to stress though, there is no substitute for this. By far the easiest way of reducing vulnerability is to prevent incidents from occurring. No incident, of course, equals no claim. Now, we often get approached by road agencies and say, well, can you help us to make our policies and our objectives and our standards, etc., more watertight, make them actually easier to defend in court? Well, is that really the way to go? Is that really good for anybody? And I will question that, and I will question those motives if people do outcome. I'd much rather talk in terms of making sure that what we specified perhaps in the head office is actually being implemented in the full, in practical terms at the regional office level, etc. I'd much rather put a lot more effort into that and being able to answer that question. If what we're doing is reasonable, if it is, then we can sit easy. We can not relax, but we can actually be fairly comfortable that what we're doing is what our peers might be doing, and it's reasonable what people on the street will consider to be reasonable under our duty of care. Often we overestimate what people expect. And if we just set out what we've done, our policies, etc., and how we've implemented them, often it's enough. Often it's compelling. Often it's very, very valuable. All right, so the insight, as we said, just want to touch on a little bit more information. If you do want to know more, then I'm very, very pleased to say that our long-standing legal liability workshop, or legal issues facing road agencies as it's now called, they are coming up in Sydney and Melbourne in a month and a bit's time. If you are interested, then please contact our training team, training@arrb.com.au for further information. They are a highly interactive day. We go through a number of case studies, but then also we help in areas of reducing vulnerability, record keeping we talk about, and how to set that up. So a very valuable day for those of you working at the real practical level, working at the sharp end, as I always call it. You receive the claims, you have to provide data to your management or your legal representatives. But there's more. I'm very pleased to say that if you are interested in going to one of the workshops, if you mention that you've been listening to this webinar, we will give you $100 off the price of attending the workshop. So it might be quite a good little sweetener for some of you there. So if you are interested, please, as I say, contact our training team. Well, if there are no more questions,
I do just have one question that's come in, Paul. It's from Nahin, and he asks, what about drive to the condition? Can government agencies defend them with this?
Yeah, absolutely. The actions of the driver, the people involved, the road users, is considered during these cases. Yes, very much so. There are expectations that people, yes, they do drive to the conditions. But we also need to be realistic and know that a road surface with low skid resistance in wet conditions is going to be even more risky or hazardous, if you like. But yes, there are considerations as to whether the speed that people were driving at, whether their tyres were correctly inflated, whether they had tread, etc. It's a very thorough investigation, a very thorough test. So that's brought into there. May have heard of the term contributory negligence, and that's the sort of thing that people will look at. What role has the road user contributed to the main downfall?
Okay, fantastic.
Okay, so no further questions?
No, that's all, but I do have one last question for you, Paul, and it's probably a favourite that you often received. If there's one message for our audience to take away from this presentation, what would it be?
Don't think of the courts as anything more than an extension of the lay public. That's all they've been set up to do. They're nothing special in terms of the way they look at claims that go through to the ultimate destination if they go through to the court. They are judging reasonableness just as what we used to call, in the very early days of negligence and liability, the man on the Clapham omnibus. And basically what that means is you could take anybody off the street and say to them, as a road agency, we are going to do X, Y, Z, and we did it. Now, do you think that's reasonable on a balance of probabilities, 51% or above? People often think the test is a lot harder than that. It isn't. And people think about the courts as, oh, it's the ultimate examination. We're going to be, every minutiae is going to be put in immense detail, and the knife's going to be twisted, etc., etc., etc. It is just a test of reasonableness, and we mustn't forget that for these sort of claims.
Okay. Great, fantastic. Well, thank you everyone for joining us today. I will just remind everyone that there'll be a survey that will launch at the conclusion of the webinar, so we always ask for your feedback, so please feel free to let us know any thoughts, or if you've got any further questions, you can pop them in there. So that's the end of
Yeah, please do. Please, if you think of something driving home or later on today when hopefully you have a nice cold beer after the day's work, send me through your question. Happy to answer it. Give me a call. I'm very happy indeed. And I know the team and our training team work with them a lot, and I know very well that if you have any more information you need about anything to do with training with ARRB, they'll be equally pleased to help you.
Okay, great. Thank you very much, Paul, and thank you everyone for joining us. We hope you have a wonderful afternoon and that you'll join us for our next webinar. Thanks very much. Bye.